everyone. Good afternoon. Thank you so much for coming to today's presentation. My name is Kimberly Soto, and I'm the owner of the Soto Law Office. Today we're going to be talking a lot about guardian advocacy, and then we're also going to touch a little bit on special needs planning. A little bit about myself. I actually grew up in the Boston area, so I'm from the north where it's quite cold. I moved down here for undergrad where I attended Rollins College. The weather here is much nicer. I went up to George Washington University Law School in DC and remembered how bad winters are. So I graduated in 2011, moved back to Central Florida, and I've been practicing here ever since. And I opened up my own firm in 2014. So the first thing I want to discuss is, when is a guardian advocacy used? So in Florida, parents are the legal, natural guardian of their children. So there's nothing special that needs done. It's just an automatic right that once you have a kid, you are their natural legal guardian. That means that you're in charge of the decision making. So you're the one who decides where they live, where they go to school, what extracurriculars they do. However, once they reach the age of 18, they're automatically considered an adult. It's anyone who reaches the age of 18, you are no longer a minor, no longer a child, and you are in charge of yourself and all of your decisions, whether they be good, bad, or indifferent. So what happens when someone who has special needs turns 18? Unfortunately, the same thing. They are in charge of their decision-making powers, and parents and caregivers no longer are able to contact doctors on their behalf. The doctors and hospitals are not supposed to give them information because they are no longer their guardian. So in those cases, we can file a guardian advocacy. So a guardian advocacy, it is a court process. So that does mean we are filing documents with the clerk of court, and you are going to eventually go to a hearing, meet with a judge, and a judge is going to rule as to whether the person applying to be a guardian advocate should actually be appointed. And so a guardian advocacy is a specific type of guardianship under Florida statute, and it relates to someone with a developmental disability who has now turned 18. And Florida statute specifically describes what a developmental disability is. So if someone has been diagnosed with one of these disorders or syndromes, then they qualify for having their guardians file a guardian advocacy. It does have to manifest before the age of 18. So there does have to be documentation that it has actually manifested before the age of 18, and it has to constitute a substantial handicap that is going to continue indefinitely. So these are the requirements that have to be met before a guardian advocacy can be filed. If someone does not meet these criteria, there is a different type of guardianship that can be filed. The biggest difference between a traditional guardianship and a guardian advocacy is the ease of the process, the timing of the process, and the cost of the process. So for a guardian advocacy, guardian advocates can represent themselves. They are not required to have an attorney. One is suggested if you are not familiar with the way that the process works, but one is not required. In a traditional guardianship, the guardians do have to be represented by an attorney. So that automatically is going to increase the cost, because not only are you paying the clerk filing fee, but now you're actually paying a professional to make sure that all of the documents are filed. The other main difference between a guardian advocacy and a regular guardianship is that under a guardian advocacy, you need a note from a doctor, like the primary care physician, dictating what disorder or syndrome has been diagnosed. And that is sufficient for the courts to move forward. For the other type of guardianship, they will actually appoint a 3-person committee. Those 3 people will review medical records, meet with the ward, and determine whether a guardianship is actually necessary or not. So it's just a longer, more complicated process. So if we can file for guardian advocacy, that's usually the better route to go. Now, this is a long process in terms of the whole process itself will actually last for the entire life of the ward. That's because once a court grants guardianship, there are going to be additional requirements that the caregivers and the guardian have to fulfill every single year. It's definitely much more weighted at the beginning in terms of the work that is required. So at the beginning, you have to file the appropriate paperwork with the court. For guardian advocacy, there are forms that you can find online that have been approved by the Supreme Court. The Orange County Courthouse has approved them. So they really do try to assist the caregivers and parents with giving them the means to be able to do this themselves. And so those forms can be found online. The potential guardian does have to meet certain qualifications because it won't just be an automatic guarantee that whoever is applying or seeking to be appointed as the guardian advocate will actually be successful in that. There is a background investigation, an education requirement, and then, as I said, there are annual reports every single year that have to be filed. Are there any questions so far in what we've gone over? Okay, I think we have one up here.
I have heard that they changed that to every 2 years to be filed. Is that true?
No, it's still every year.
My
Yep.
guardian attorney told me that.
I haven't seen that yet. It might be something that they're in the process of doing, but I haven't seen anything yet. I think we had one back there.
The qualifications under developmental disability, is that a new thing? Like 5 years ago, 10 years ago, was that how it was set up for guardian advocate, or is that kind of new? That those automatically qualify you to qualify for guardian advocacy?
That's a good question. I'm not sure specifically when this part of the statute came into being. It's been that way for a significant number of years, though.
More than 5?
Yes. Okay, I think we have one way in the back.
Thank you. Will the PowerPoint be available, or do we have to write it out?
Yes, if you would like to approach me after the seminar, I can give you my business card, and if you send me an email, I'd be more than happy to supply the PowerPoint. And I believe it might be available through the Family Cafe. Yes?
Can the parents be guardians and then also like an older sibling? Can they do it all at the same time?
That's a great question. I'm going to hold off on answering it, though, right now. Okay, so let me go on to the guardian qualifications. So this goes over who can actually apply to be the guardian advocate for another person. And Florida differentiates between whether you're a resident of the state or whether you're a non-resident. So if you're a resident of the state, it's anyone who has legal capacity themselves and is 18 years or older. That's it. Those are the only qualifications. So that could be a parent, a sibling, it could be a neighbor, a caregiver, really anyone who has full capacity and is over 18 years old. So it's a pretty broad allocation that people can fill. Now, if you're a non-resident, Florida statute kind of brings it in a little bit. You do have to either be directly related to the ward, a legally adopted child or adoptive parent, or the spouse of anyone who qualifies. So if you are not a resident of Florida, then we are looking for the family connection. And so that's the big difference between someone who's a resident of Florida and someone who's not. Traditionally, I will say, normally people are going to be a resident of Florida. Where you file the guardian advocacy case is going to depend on where the ward is living. So wherever they're residing is going to be the county that the paperwork is filed in, and normally who's ever seeking to be guardian advocate is actually their caregiver living with them, taking care of them, or is in the same vicinity. It's not often that we have a resident from out of state who wants to qualify for an in-state guardianship. And now, what is a standby guardian? So in Florida, once a guardian is appointed, they are able to serve until they are removed. Certain things will automatically remove them, such as their death, their incapacity, or if a court finds that they have breached their duty to the ward, and so they would have to be removed. If one of those things happen, during the earlier part of the guardianship case, even immediately when you file, you can file what's called a petition for a standby guardian. And so that's the court at the very beginning of the case or at any point during the case determining that if you can no longer serve as the guardian, they've already picked who your successor will be. So it's already someone who is set up so that they don't have to go through the long process of filing a new guardianship application, filing a new petition, which can take a while to get through the court system. So a standby guardian is just that. They're on standby if the guardian who's been appointed can no longer serve. And so there would be an order designating them as the guardian standby, And then once they have to actually take and step into the shoes of the guardian, letters would then be issued by the court, which actually give them the authority to act. Okay, so another step that the proposed guardians have to go through is a background investigation. So that consists of a credit history investigation and a criminal history investigation. So how this works is that once all of the initial paperwork is filed with the court, you'll get what's called an ORI number from the clerk, and you'll actually take that number to the fingerprint location of your choice, get your fingerprints taken, and then the ORI number is what the fingerprinting company uses to link your fingerprints back to your case that's actually with the clerk, because they can't move forward with appointing you as a guardian until the clerk has received both of these reports back and had a chance to review them and make sure that there's no conflict or reason why the person would not be qualified to serve as guardian. One thing to remember on the credit history report is if you've locked any of your credit scores so that they can't be run, that also stops the clerk from doing it. So if you have locked any of the three, you're going to have to go ahead and unlock them just for the purpose of this. Now, there are a couple automatic disqualifications under Florida statute. So if someone has been convicted of a felony, they won't be entitled to serve as guardian of someone else. If you have been discharged of duties of a guardian before because of incapacity or illness, you won't be able to continue serving because you can only serve as guardian if you yourself have the capacity. If you have been judicially determined to have committed abuse, abandonment, or neglect, or if the court finds that you are otherwise unable to perform the duties of a guardian. That's a pretty kind of broad statement that can encompass a number of things, but usually the courts are really looking for the first three. And so that would automatically disqualify someone from being able to continue on and act as a guardian advocacy. Yes?
Regarding the background, is any, like, if you have a background done for some other backgrounds conducted by the state, can that be transferred to the guardian, or is that completely done already?
No, that's a great question. So the question was if you've already had your background check done for some other purpose, can that be used? And unfortunately, it can't. The clerks want their own to be run. They give you the ORI number so that it can tag it. So it will be a new thing that you do have to go through the process and pay for. All right, I think we have one in the way back. That's a great question. So the question is, what happens if there's two divorced parents? So how does the guardian advocacy really work, and how do you file it? So you have a couple options. Either one parent can file for guardian advocacy, and they'll be appointed as the sole decision maker, and then the second parent can be the standby guardian. So if something were to happen to the first parent, then the second parent would step in as the guardian. Or you can file for co-guardianship. So you can actually be co-guardians together over the same person. So it really just depends on the family dynamics and what everyone prefers to do. Because of course, there can be pros and cons for each way that you can go. And I think there was one a little up front. Yes.
So when you file, you were saying you do it by yourself. So I live in Sarasota County and my son's in a group home in Hillsborough. But if I wanted to do the advocacy, I would file in Hillsborough where he's staying with that court, or can I file in Sarasota because that's where I live?
You would file where he lives, wherever the ward is domiciled. Now, if it's something, though, that your home is truly considered his home and he's just staying there temporarily, then you would file where he lives, which would be with you. Yeah, so that's just kind of a factual question as to where does the ward reside, not necessarily where do they spend most of their time.
Oh, okay, so all his mail and legal stuff is my house, my county would be fine.
Yes.
Okay.
Yep.
Thank you.
Were there any other questions at this point? Okay, we got one in the front row.
Question, what's a good time to start filing? So my daughter's 16, do I wait till she turns 18 to file it? Which then you gotta wait for all the paperwork to happen, or do you do it 6 months before?
We recommend starting the process 6 months before so that you can get all the paperwork ready to be filed, get everything set, figure out what the ORI number is, where you're going to go get your fingerprints, and then you can file right when they turn 18. And the courts can, if it's an uncontested guardian advocacy, they can be moved through fairly quickly. It's something where if there's a contested guardian advocacy, that means that 2 different people, or more than 2 different people, think that they should be appointed as a guardian advocate without the other. And so then that's a contested case that could take a significant amount of time.
Is there like a window that, you know, is open, so you're still the guardian until it gets approved?
No, because once they turn 18, they are their own autonomous being. And so you have to wait until,
During a few weeks, maybe they might be without a guardian?
it could be a few weeks or it could be a few months. It depends on the court system and which county you're filing in, how many cases they have, how backed up they are. Okay, I think we have another one in the front row.
Yeah, I have, I guess a couple. One is, can it be undone? In other words, you know, somebody might not be ready at 18, but they might be ready at 25, 30, something like that. Can it be undone? And two, I'm a little nervous about the whole idea that at some point the court could just assign a guardian.
Okay, those are 2 great questions. So the first question is, can the guardianship be terminated at any point? Yes, so if the guardianship is no longer needed, so the ward has reached capacity, they no longer need assistance with decision-making powers, then the guardianship should be terminated, and there is a process to go through for that. And that is, you know, the responsibility of the guardian if, you know, they believe that the ward has the mental capacity and that the guardianship should be terminated, then you can file a petition to terminate, explain the reasons why, and then a judge can determine whether they agree or not. And then the second question was, you're nervous about.
Random people court pending.
Okay, so the concern is that because, let me make sure I'm understanding the question, because as a resident of the state of Florida, anyone could technically apply to be a guardian over anyone else, that the concern is that a random person not connected to the ward might be appointed?
Yeah, well, I've read where somebody who was considered not in capacity was assigned by the court a
Guardian.
And so, you know, I'm thinking, okay, what if your plans A and B, you know, both die in a car accident, and then now you've got somebody who the court has, you know, documented not capacity, and then the court has to assign somebody. So I guess that's.
Absolutely, that's a great question and also a valid concern. So the question and concern are, let's say that the original guardian that's appointed passes away and the standby guardian passes away. So then what's going to happen to the ward? Because there's already a guardianship case open, once the court is aware that those 2 people have passed away, they are going to be required to appoint someone. So hopefully it will be someone in the ward's life, you know, another family member, maybe a caregiver, maybe, you know, someone who is a neighbor with the ward, someone who is aware of the situation and willing and able to step into the shoes as guardian. If not, though, the courts can appoint a professional guardian. So it is definitely something that happens, but, you know, we try to prevent that by having kind of a long list of what happens if, and then, of course, hopes that, you know, that is not the case. I think, yes.
Yeah, off of her, is there an age limit that, like, because I waited, because I thought maybe they would have it when they were a little older?
Yeah.
Is there an age limit that it's too late to get guardianship advocacy?
No, there's not an age limit for when it's too late to file for guardian advocacy. However, you do have to prove that the guardian advocacy situation was before they turned 18. So as long as you have the paperwork, that sometimes is where the stickler comes in. But if you can't file for guardian advocacy, like I said, then you can file for the traditional guardianship route, which is a little bit different, but it's not like there aren't any options available.
Yes, ma'am, I wanted to follow up. You talked about at 18 when they become an adult, obviously we wouldn't be able to communicate with their doctors and things of that nature. But are you saying that for filing the guardian advocacy, do we have to wait until they turn 18, or can we do it ahead of time in preparation of that age?
So the court can't actually appoint a guardian until the child is 18, because until they are 18, they're the natural the parents are the natural guardian over them. So that's where kind of the issue comes in, is it's a jurisdictional question, and whether you may be allowed to file earlier is going to be a county by county determination, and basically how the clerks feel about the cases and whether they reject them because they read the paperwork and see that the ward is not 18. So that's a county by county specific question that would have to be dealt with. Over there?
Yes, what if you have an adult, a young adult, who's technically very high functioning but has made some poor decisions, and you seek guardian advocacy? And you don't have to take over everything, but you can step in when needed. But he understands at 18 he can take you out of medical and any
Yep.
other services so that you can't get any reports. But he chooses to fight the guardian advocacy. Do you continue with the guardian advocacy, or do you move over to the 3-panel and go for full guardianship?
That's a great question. That's also going to be a very case and fact specific question. So the question is, if you do have someone with a developmental disability under the statute, but that the ward, they don't feel that they need a guardianship, and so they're going to fight the guardianship and they would like to retain full rights over themselves, kind of what are the options? What can you do? So in terms of guardian advocacy is actually a very limited type of guardianship. There are only certain powers that the court will grant to the guardian. So it's different than the traditional guardianship because there's not the opportunity to have a full guardianship where all of the rights are given to someone else. So one way is that if that can be explained, that it's not all of the rights, that are being gifted to someone else to act on their behalf, it is limited. And then the other question, or the other part of it was, is there an opportunity to maybe move into the traditional type of guardianship? And that may be needed if the rights of the ward really need to be more fully assisted with. So that's really going to be a factually specific question as to what the ward needs assistance with and what the guardian is seeking. And then if the ward fights it, they are always entitled to have their own attorney who can come in and argue on their behalf that a guardianship is not appropriate and is not necessary. And at the end of the day, it would be up to a judge to determine whether the guardian advocacy should be granted or denied. I think we had a couple other questions. Okay, let me do this one.
So I'm going to switch back to that whole you have to wait till they're 18. So let's say you have somebody and you can't get into the courts till they're 18 and a half. So for that 6 months, he could make terrible mistakes and not be, that's scary for me because
Yep.
my son does not have the capability of making these decisions.
Yes, so now they do have emergency powers. The courts do have opportunities to be able to appoint someone in a quicker manner without going through kind of the full process on a temporary basis. So if there are certain circumstances where we are immediately concerned about the safety and health of the ward, then we can file on an expedited emergency basis. So there are tricks that we can use, but it is a very factually specific situation. I will tell you, the courts and the judges and the clerks, they're all wonderful. They are aware of these situations and how kind of that there are some situations where it's very urgent for someone to be appointed. So we can usually work, with the judges and the JAs and the clerks. We work in these counties all of the time, and we're constantly, in touch with them, appearing before them. So there are definitely tools that we can use to make sure that everyone is protected and safe.
So what you said before about everything that we have to do, we need to have that done pretty much before their birthday and get set up so we can get into court.
Yep, we can do everything as quickly as possible. Yep, and as early as possible. Yep, so that then everything is ready to go.
Okay.
Yep.
Actually, kind of heard the same thing that we're going. So say she turns 18 and she gets sick the exact same day, winds up in the hospital. What do you do then? Because I run into this with my parents with Alzheimer's and dementia.
Yep.
Paperwork, and you better hope, even though cannot move, cannot get a word out, they will, you gotta show the paperwork.
Yep.
But that was scary as that kind of window.
Yeah, and it.
So what would you do in that case? Is there like a special, just because if they're in the hospital, you gotta make medical decisions.
The only thing that you could do is to try to file it as an emergency guardianship to get a temporary appointment that would carry you through. But I will tell you kind of the reality is if someone is in the hospital and they're unable to communicate or clearly unable to make their own decisions, the hospital staff is going to usually look to someone. So, who's there, who's available. Now, that's not a guarantee, but it is something where the practical side and the legal side, unfortunately, don't always match up. And so it's just, we have to do the best we can with the deadlines that are prescribed for us, and also hope that we don't have to utilize, those emergency powers. I think there was a question up here.
And I'm gonna go way back to the standby guardian.
Okay.
So, I already had guardianship, guardian advocacy with him since he was 18. He's 23 now, but I didn't
Okay.
do a standby guardian.
Okay.
Now, what do I need to do now to do a standby guardian?
Great question. Okay, so the question is, a guardianship has already been established, and so a guardian advocacy has already been appointed about 5 years ago, but there was no standby guardian done. So what happens now? You can actually go ahead and file now for a standby guardian. So it's a separate petition and application, and they go through the fingerprinting process, the background checks, but you can just simply start that process within the guardianship case now. So it can be done at any time. It can be done.
Go back to the original attorney that did it? I mean,
No, you don't have to.
do I go to the court myself or get an attorney and guardian?
It's a personal preference. So the question was, should she do it herself or go to an attorney's office and hire an attorney? That's certainly a personal preference as to which one you want to do.
Do it yourself?
Yes, you can do it yourself. For guardian advocacy, you are able to do everything yourself. But if you're not familiar or it's a difficult case, or honestly you just don't want to spend the time doing it, you also can hire an attorney. Both of them work well. And for the standby guardianship forms are also available online.
Okay, thank you very much.
That was actually my question. So,
Oh, okay, great. Okay, then we got one behind you.
So, she spurred something else. In my will, I have who I want to be the guardianship after if something happens to me. Will that suffice, or do we need to go ahead and get the person that we want to have the guardianship in my passing?
Great question. So the question is, if in your will you have dictated who you would like the successor guardian to be, is that sufficient, or should you go ahead now and go through the process of having a standby guardian, having that person appointed as a standby guardian? We would suggest you go through the process of having them actually appointed as a standby guardian. The reason for that is the person who you appoint in your will as the guardian will always have preference. So the court will look to that person to be appointed. It's never a guarantee, because what if they don't qualify for another reason? But they're going to have to kind of start the process over again in the same case, in the sense that they're going to have to file a petition to be appointed as successor guardian, do the application, do all the background checks, do everything. Whereas if you go through that process now, it's going to speed it up, because the concern is always, right, now that the guardian has passed away, become incapacitated, stepped down, well, now there's a lull between when the next guardian is going to be appointed. So anything that you can kind of do now to take that pressure off is helpful. Yes?
So, can power of attorney do the same things?
That's a great question. Okay, so the question was, can a power of attorney do the same things? So a power of attorney is a wonderful, amazing, excellent document. In order, though, to execute a power of attorney, you have to have the mental capacity to understand the document, understand what rights you're giving away, and understand who you're giving those rights to. So usually it's going to be one or the other. Either you have a situation where the person can sign a power of attorney, can sign a healthcare surrogate, can sign a living will, because at some point when they sign those documents, they have the capacity to do that. And that would be wonderful and great if that could be every situation, because then guardian advocacy is not needed. However, the reality is that if you have to go the route of guardian advocacy, it's because they don't have that ability. The law has deemed them mentally incapacitated to be able to execute those specific documents. So they don't work together. It's usually an either or. Are there any questions in the back? Let me go way to the back. Oh, you.
I actually have two kind of questions. One, if you have a power of attorney before they become incapacitated, that can work?
Okay.
You don't have to go through the process?
That's a great question, but one that would never kind of fit the facts, and here's why. So in order to file for guardian advocacy, remember you have to be diagnosed before you're 18. And so a minor would never be able to sign a power of attorney, a living will, a healthcare surrogate. Now, if it's something where someone later in life lost mental capacity, like Alzheimer's, dementia, maybe a car crash or a stroke, that wouldn't fall under guardian advocacy. That would be the traditional guardianship route. And then if there was a power of attorney, healthcare surrogate, all of the documents were executed while they were mentally competent, then you wouldn't even need to go the guardianship route, because you would already have those documents in place that give someone the same rights and opportunities as a guardian.
Okay, my second question was, if a court appoints a traditional guardian, would it be easier if a family member came forward to be able to take over the guardian, or would they pretty much stick with the court?
I think I understand your question. And so the courts are always going to prefer that a family member is appointed as guardian. So it's kind of an automatic presumption that we assume that a family member is a better fit than someone who is not family. However, that is a presumption that can be overcome. So if for some reason, that person hasn't been in the ward's life, has never seen the ward, all of a sudden though the ward was in a car accident and now is worth $5 million, and they have come out of the woodworks to be guardian, as opposed to maybe a neighbor who has been taking care of them, who has taken care of the family and been in their life, is the godparent. In that situation, a court is going to have to weigh the pros and cons of each person and who is more qualified. Because a guardian has to look out for the best interest of the ward. So it's a fiduciary responsibility for you to actually make sure that you're not doing the best for you, but for who's ever in your care. And that is a high burden and a high standard that the courts do hold you to.
Would it be more like a sister that wasn't qualified prior because of age?
Oh, okay.
Now is qualified because of age, and there's a state appointed guardian. So that person that's now of age, and it's
Oh, okay, I see what you're saying.
the sibling, all of, the whole time.
Okay, so
To the sibling versus the court appointed.
So the question is if, so a guardian was appointed, and that guardian, I'm going to just assume, passed away, and so the next relative would have been the ward's sister, but they were 16 at the time, so they can't serve. And so there was no one else available, so it was a professional or court-appointed guardian that ended up stepping in and taking over the care. Once then the sibling reached the age of 18, they were interested in becoming the guardian. The issue with that situation is once a guardian is appointed, in order for the guardianship to change, they either have to agree to voluntarily step down or they have to be removed. And the ways that someone is removed as guardian is if they become incapacitated, if they die, or if they breach their fiduciary duties to the ward. So in that case, it's really going to be a factual question for what's going on, and then also kind of a concern as to, why is the professional guardian not wanting to step down if they don't? Is it because there's big dollar signs, or is it because of a legitimate reason where they don't believe that the family member would be the best qualified person? So that's definitely, the court can look at it if the sibling who's now reached the age of majority has reasons to bring it to the court's attention. It wouldn't be something just because, it wouldn't be sufficient just for her to say, well, I'm the sister, so I want to be guardian. There has to be a reason that the guardian should be removed if they don't voluntarily agree to step down. And then we had a question right in front of you. Yes.
I'm trying to decide, I need to appoint my daughters, I have plenary guardianship, and at the time when I got it, they were minors, and now they're over the age of 18. Is it better to make them standby or co-guardian?
Okay, so you have plenary guardianship over someone, and your two children were minors when that happened. Right. So now the question is, now that they're adults, what's the best course of action? Is it standby or co-guardian? That's really, once again, going to be a kind of a family-specific decision. Having someone be appointed as co-guardian now means that either person could make decisions, which can make things easier if someone goes on vacation, if someone's out of town. It can also make things harder if they don't agree. Because think of the situation of someone's in the hospital and I have co-guardianship with my sister Michelle. Well, I say, yes, the ward wants this treatment and these meds. And then the next day, Michelle says, no, we don't want to do this treatment or these meds. Then what is the hospital supposed to do? They can't flip back and forth and, put someone's health at risk. So then that's something that would end up going back to the judge because the judge would have to make the decision. So that's why whether it should be co-guardian or standby or co-standby guardian is going to be a really specific determination for each family. I'm going to actually hold on questions for a minute just to keep going a little bit, but I will take a break in a little while. Okay, so we went over the disqualifications. So once you have done all of the steps that we've talked about, you filed all the paperwork, the background checks are done, you have now been appointed as guardian, you've gone to the hearing, the judge has agreed that you should be a guardian advocate over the person who you're seeking the guardianship over. You have 4 months after that hearing where the orders appointing you as guardian and the letters appointing you as guardian are signed to complete your education requirements. So if you are guardian of the person only, you're going to have to go through the training for the guardian of a person. If you're guardian of property, you go through a different training. And if you're guardian of both, you would go through the training. So there are educational requirements once you are appointed, courses that you do have to take, and the clerks all have authorized providers for these classes. So they actually have a list because each county is different, and some of them are online, some of them are not online, but you do have to go through the education requirements. Now, there are some situations where you could ask a court to waive this requirement. You could say, I don't think it's appropriate for me to have to fulfill this. A judge is going to have to agree with you on that. Times when we kind of see that happening are if, let's say, you were a guardian over the ward in Massachusetts and you had been guardian for 30 years and now you move down here with them, and so you have to seek appointment of guardian in Florida. In that case, maybe a judge would say, okay, you know what you're doing, we trust that you know the steps, or they may say no. They may say Florida's its own beast. Florida has different rules and regulations, and we want to make sure, since we are appointing you as guardian, that you know exactly what your rights and responsibilities are. Oh, absolutely, yes. Yeah. Yes. I'm sure the providers would welcome another person to take the course. Okay, so another requirement that you have to do is the initial guardianship report. So within 60 days after being appointed, if you're guardian of property, you have to file a verified inventory. And if you're guardian of person, you have to file the initial guardianship plan. So the initial guardianship plan is going to include stuff such as the medical, mental, personal care, social services that the ward is receiving, and then the place that they're residing and why that meets their needs. The verified inventory would list all of the assets of the ward, the value of them, a description of where they are located. So that's the verified inventory. That's a great question. I have not personally gone through the training, so I am not sure how much they cover or how in detail they cover. I would assume that they do cover all of these things since it is after you're appointed, and these are all the requirements that you do have to meet. And earlier I had said, remember how it doesn't, these cases aren't quick or short. They last for the entire lifetime of the ward. And so the reason for that is once a court has decided that you are an appropriate guardian for someone else, they're giving you a lot of responsibility. They are, making you in charge of someone else's decisions, and they have taken those decisions away from that person. So the courts want to make sure that you are not abusing your power, you are ensuring to keep the ward's best interest at heart, and making sure that you are doing the right thing and not breaching your fiduciary duty. So every year, reports have to be filed. And so that is something that the clerks do follow up on. If they're not filed, they will issue orders to show cause, and you will either have to file them or go in front of the judge and explain why you have breached your duties as the guardian. So like I said, the clerks and judges are wonderful to work with. They understand that everyone has a lot going on. One option that you have is even after you've been appointed guardian, you can hire an attorney simply for the annual plans. My office, we have a running checklist of everyone's annual plans that are due, annual inventory. We make sure that we contact them. Hey, just a reminder, here's the attached form, make sure you fill it out. For the annual plan, you do have to get a doctor to sign off on it. So there's a physician's report. So you got to make sure that that gets done. And there are time limitations when these have to be filed each year. And you definitely want to make sure that you are filing them in the appropriate time. And there are time limitations as to when the doctor, the physician, can fill out that report. So it can't be too old. It can't be something from 8 months ago. The doctor said, yep, the guardianship is still needed. So the timing of this is very specific. And so that's also an option, is that you can hire a law firm who, we have systems in place to manage it, to make sure these don't get missed. Because you definitely don't want to get too many orders to show cause notice for you. Yes, let's go just for some questions.
If you have, or you're initially going through an attorney to file, they can request the court to waive those, can't they? If you're parents of the child.
They can usually request, to have the education requirements waived. That's not a guarantee that the judge will grant it. For the plans, I have not seen judges grant them. They do have to be filed every year. Sometimes for the accounting, you can file what's called a simplified accounting, and that can be requested, but that really depends on the specifics of the case and whether it's appropriate or not. I think we had one in here from earlier.
To kind of go back to what you had said about the like supplemental guardians, in setting up my estate planning right now, like for example, I have a son that's 18 that at some point in time would logistically probably take over the care of his sister.
Okay.
Can I designate as part of my estate planning that, if there was a period of time where I was incapacitated and not able to care for her, but he's not ready to take on that responsibility, that a temporary one be appointed, but that it's my wish that he take it over at a later date?
That's a great question. And I'm going to say no, but I'll explain why. Okay, so the question was, so if I am appointed as guardian over my daughter, and my son is 18, but he's not ready to take on those duties if something were to happen to me or I became incapacitated, is there some way that I could appoint someone kind of in the interim? So if I became mentally incapacitated or passed away, I want to appoint our neighbor, Michelle, to be guardian, but only until my son is ready. So unfortunately, no, that is not something that can be done, because when the standby guardian is appointed, they're appointed as guardian until they're removed. So it is something that if they voluntarily step down, or once again, they became incapacitated, but once a standby guardian becomes the guardian, they are the guardian until those steps are followed. So it is something though, if everyone's kind of on the same page and can talk and can agree, and if there's enough trust there that we think everyone will follow through, that's kind of the situation that you're looking at. Yes?
Is there a maximum number of standby people you can list?
I guess technically, no, but practically speaking, yes. So the court is going to only appoint like one standby guardian. So it would be, I'm the guardian, and then my child is going to be the standby guardian. Then if something happens to me, my child gets appointed, and now my neighbor is going to be appointed as standby guardian. So there's usually only going to be like one level of standby guardian officially appointed by the court at any given time, unless they're like co-standby guardians. Does that answer your question?
No, because you threw it in the neighbor.
Oh, okay, just another person.
Yeah, but you said it was if the son then passed, then the neighbor could do it. But you said really only one, so that's like 2 standbys.
One at any given time. So if I'm guardian and then...
But you can list, like, if so-and-so dies, then it's this person. If this person can't do it, then...
In your estate planning, yes.
Okay.
Yeah, in your estate planning you can, just not formally with the court.
Okay. What document would that fall under?
Your will.
In my will.
Yep. Are there any questions in the back? We got one there?
So, co-standby, does that mean you can appoint 2?
Yes.
So you could do, let's say, because I have 2 girls, and I wouldn't want to pick one over the other, but someone suggested you can have a standby guardian over the person, and the other one be over the property.
That's a great question. So the question is, can you have co-standby guardians? And yes, you can. You can have co-standby guardians. You can have co-guardians. And then the other part of it was, instead of doing it that way, could you have a standby guardian of the person and then a standby guardian of the property, so that they would serve in two separate roles, and that you can also do. Just some things to think about though are, there are pros and cons to it, right? Because you are splitting the duties, so now it's two people kind of checking in on the same person, even though they're guardians of different things. They both still are involved in the life and the decision-making process. So that's always good. It's siblings, so no one feels left out. Each of them have their own roles and their own input and care. But you have to also think about the reality. So what if the guardian of the person needs, something medically paid for, and the guardian of the property has decided to go off to Cancun for 2 months to live their life. Well, how easy is it going to be able to get them to sign a petition, to petition the court, to authorize the expense for this medical needs that's needed, and then the guardian of person can't supply that until they have an order from the court, they get a check written by the guardian of the property. So it's just logistically, are things that you want to think of, how in reality is this going to work out? Because we always, look at it as attorneys from a legal point of view, but we also want to make sure that what are the actual steps that you're going to have to go through, and is everyone's needs going to be met?
So if you're,
I'll come back to you real quick. Right back there?
Yeah, in those cases where there are family or friends available to take over once a guardian passes on, are there organizations that offer guardianship services that that person could designate beforehand in lieu of letting the court appoint professionals?
Absolutely. So the question is, what happens if there are no family, friends, neighbors, anyone who is able to step into the shoes of a guardian who has now passed away or is incapacitated? Are there professional associations that you could designate? And yes, there are. There are professional guardians. So it is something that you could work with them individually to, ask them to be appointed as the standby guardian and figure out, logistically how that would work and what that would mean. But there are professional guardians that can be appointed. Honestly, you can Google professional guardian, but we work with a bunch of professional guardians, so you could ask some law firms for some recommendations for how to find professional guardians, or ask around, ask your community, friends, family, other people who have been through this. Hey, did you ever have a professional guardian? Do you know anyone who has? Because that is going to be a very personal decision. So you definitely want to make sure that, if you're looking to go the route of a professional guardian, that they understand, what the ward's needs are, what the ward's wants are, what you envision for their future. So it is something that's a very personal decision. And so you want to make sure that you're very comfortable with whoever the guardian is that you're picking and you're designating. Did we?
yeah. So
Okay.
back to your thing with the two. If they, your Cancun story, but say you only have the one guardian, say I'm guardian and I want to go on vacation and something happens to my child while I'm gone, I can leave them with somebody else to take care of them, correct?
Yes, okay, so great question. So the question is, if you are guardian of the person, you're full guardian, so there's no other co-guardian or anyone else, but you want to go on vacation without the ward. Of course, that is allowed because you, as the guardian advocate, you have power over their decision making. But that does not mean that you have to be tied to them or take them everywhere with you. It's something where as much freedom and independence and decision making abilities as they have, you want to give them. It's not something where just because you're guardian advocacy now, you're like, okay, well, you can't do this, this, and this, that you were able to do, you were able to make good decisions about, you were able to determine on your own. You definitely always want to give them as much, distance as they want and as they're able to handle. Are there any other questions? Let's go back there.
Two things, a response to the question about asking a judge to waive the accounting or waive the other. In our case, the judge did waive the accounting, so we only are responsible for the annual plan.
Okay.
So,
Oh, that's wonderful. Is that because there was only a limited income?
I don't know the reason for it, maybe that is.
Okay.
Okay, so that's one thing. The other thing, my question was, when you talk about standby, I do need a successor.
Yes.
Okay.
They're
That's the term that was used on our paperwork for our
Yeah, they can be interchangeable, standby or successor. We usually use standby guardian as someone who is like pre-appointed, and successor guardian is when there was no standby guardian, and so now you petition to be a successor guardian. Is normally how we use them, but they are fine to be interchangeable. Yes.
We also had the accounting waived, and it was because his only asset was his SSI check.
Oh, yes, yep, yeah, if it's SSI, they will waive it. Yes, thank you for that. Yeah, that is, I forgot about that one. Let me go right back here.
Yeah, my question is regarding the standby guardian. If you have one appointed or co-guardian is appointed and you want to have a backup plan to that, did you say it have to be reflected in the will? Or what document you said have to be reflected in?
Okay, that's a great question. So in order to have the backup guardian, what should you do? So there are a couple different ways. You can put it in your will, or you can file a petition for standby guardian with the court and actually have a standby guardian appointed. So there are two different ways you can do it.
And so we're co-guardians.
Okay.
That would be two separate wills, or is there something called a joint will?
No, okay, that's a great question. Oh, I love that question. Okay, so the question was, is it a joint will if there are two co-guardians appointed? No, Florida does not recognize joint wills. So if you have a joint will, it will be thrown out and shredded as if it never existed. So in Florida, everyone has to have their own will.
So will would not be an option, we'd have to put it in another document.
Well, you could each have a will and put the same person.
Okay, thank you.
Yeah, but that actually kind of brings up a great point as to, well, what happens if they're conflicting? Then you're kind of going to be looking at, well, who passed away first, who passed away second, because second. Yep, so things to think about. You had a question up here?
The annual report that you have to file, I mean, I just do the same form every year, but I've never had a doctor have to sign anything. And I've never had a problem.
Okay.
Is that required?
Yeah, usually they have to fill out the physician's report.
In the garden, did any, had a physician ever have to sign anything?
Oh, okay.
I don't know, I mean, I'm just filling out the, and if it was a problem, they would contact me, right?
They should.
Yeah.
They should. Sometimes things fall through the cracks.
Because I've never done that, a medical form.
Not like the one-page physician's report.
Just the, I guess,
Okay.
I don't know if it's the, what's the difference between the annual guardianship plan and the annual accounting plan?
Great question. So what's the difference between the annual plan and verified inventory? So the annual plan is solely about the physical being of the person. So where the ward lives, what doctors they're seeing, what care they're receiving, what social activities they're partaking in that are advancing their quality of life. Whereas the verified inventory, solely about money. What assets does the ward have? Was there like a settlement that was reached? Was there assets that they inherited that have to be counted on the annual inventory? Do they have income that they have? So those are the differences. One is physical being and the other is financial.
Which one's physical? The guardianship plan?
Yep.
I think that's the only one I do. I don't do anything. I put all this medical information, but I've never had a doctor sign it.
That's interesting.
I know.
Yeah, and they won't, not everyone will fill out both, because if there are no assets, then you're only going to be appointed guardian of the person, and then you're only going to fill out the annual plan. So it's not like that you're always going to have to do both. And I mean, not in a guardian advocacy case, but there are other cases where a property is only involved. I'm going to move on a little bit just because we're running out of time. So I just wanted to quickly touch on special needs trust. So a special needs trust is a great tool because it allows someone to still have assets that are their own, but still receive government benefits. So there are normally two types of special needs trust. There's a lot of types of trust, but there are two kind of general types of special needs trust. One is a first party and one is a third party. And those just differentiate who actually owns the assets. So if there's a case where let's say someone received an inheritance. Well, that's a direct payment to them, so they would set up a first-party trust. The biggest negative and the biggest difference with that is that in a first-party trust, because the ward is the one who owns those assets, when they pass away, if there are any funds left in the trust and there was any benefits from Medicaid that were paid out, they will have to be paid back, even if that depletes the trust. In a third-party trust, that is a situation where, let's say me as a parent, I want to set up a trust for my children, that when I pass away, I can fund a special needs trust, And then when that child passes away, the funds remaining in the special needs trust can be passed on to another family member. It's just kind of a legal difference between how ownership is titled and passed in Florida. And then,
Can another person put money in the third-party trust?
in order to have a third-party trust, it has to be another person. It can't be the
Like
ward.
you said, inheritance. So I set up a third-party trust, but then grandma leaves them money.
Yes, so what can happen is you can set up one third-party trust and then multiple people could leave their inheritance to that one trust, or they could set up separate trusts depending on, the specifics of the family and what their wishes are.
First party. It can go into a third?
It can't go into a first-party trust.
Because you said inheritance would go into a first when the board owns it.
So that depends on how it's actually inherited. If, that's a great question. Okay, so if in my will I say Michelle is inheriting this, then it's going directly to her, and she has to set up a first-party trust. But if instead in my will I say I want it to go to the Michelle Special Needs Trust of 2017 and put all my terms of the trust in, then the trust is actually the beneficiary, not Michelle. Does that make sense? Sorry, these are all kind of like individual legal specifics.
With the third-party trust, special needs trust, it says board and a trustee. So I know that a third party needs to manage it. But does the person have to be a ward? In other words, can they be an independent, person with special needs that just has the trust?
Okay, I think I understand the question. So basically, does there always have to be a guardianship if there's a special needs trust? Is that the question? Okay, no, that's not a requirement because you don't have to have a guardianship set up in order to have a special needs trust, but you do have to, in order to have a special needs trust, you have to qualify. So they do sometimes tend to go hand in hand, but not always, because if someone was able to have the capacity to sign their estate planning documents, then they don't need a guardian advocacy because that takes care of it, but maybe they do need a special needs trust. So that's definitely just kind of a specific question for the facts of the situation. Was there, okay, there's one in the back over there.
Yeah, my 22-year-old son is high-functioning autism. Assuming that when I die, one of his 3 older siblings will be there to take care of him, and he still lives with me, at this point. What are the ramifications of me not doing all this beforehand?
That's a great question. So the question is, if you pass away without doing any of the guardianship or any of the estate planning, really, as long as it doesn't affect you, you definitely don't need to do it. There are, a lot of situations where people can kind of go through without having these legal documents in place because the people who they work with, maybe the providers that they use, they know that this is, mom or dad or spouse or sibling or whoever, and so they're a little bit maybe freely giving out information. So if you haven't run into any problems, you don't have to file for guardian advocacy. That's not a requirement, and it is something where if you were to pass away and let's say your children moved to a new county, and so it was new healthcare providers that didn't know them and weren't willing to, give out any information, at that point in time, they could seek guardian advocacy. So it doesn't matter that the parents didn't seek it. It doesn't matter that the sibling didn't seek it. It can be open at that time. Yes, in the pink shirt, I think, pink or red.
Hi, okay, you said the third-party trust, is that synonymous with the special needs trust?
It's a type of special needs trust.
Oh, okay, so if you're the trustee of that, you do not have to be the guardian also, right?
Not necessarily. So special needs trusts deal with finances. So that's going to be different from the person's physical body. So you may only need to be trustee and you may not need a guardian advocate, but not guaranteed. Okay, we are actually out of time, so I just wanted to quickly go over the ABLE Act. So this is actually something that allows person with disability to still have some funds and receive government benefits. So there are some requirements under it that I unfortunately have run out of time to get into. But I just wanted to put down our contact information. I do have some handouts if anyone, and business cards, of course, if anyone's interested. I'll be hanging around here for a little while. But thank you all so much for coming, and I hope that I provided some good information.
Thank you.